House will come to order. Please join Representative Ricks in the Pledge of Allegiance. Mr. Gregorio, please call the roll.
Representative Zamabile. Bacon. Representative Bacon. Representative Bacon is excused. Baisley. Benavidez. Burnett. Byrd. Bockenfeld. Basenecker. Bradfield. Caraveo. Carver. Representative Carver. Representative Carver is excused. Catlin. Cutter. Doherty. Duran. Escar. Exum. Froelich. Geithner. Gonzalez Gutierrez. Gray. Representative Gray. Representative Gray is excused. Hanks. Harrod. Representative Harrod. Representative Harrod is excused. Holtorf. Hooton. Jackson.
Here.
Judah. Kennedy. Kipp. Larson. Lontine. Luck. Lynch. McCluskey. McCormick. McKean. Representative McKean is excused. McLaughlin.
Good morning.
Michelson-Janae. Representative Michelson-Janae. Representative Michelson-Janae is excused. Mullica. Representative Mullica. Representative Mullica is excused. Neville.
Here.
Ortiz. Representative Ortiz. Representative Ortiz is excused. Pelton. Pico. Ransom. Rich. Ricks. Roberts. Sandridge. Sirota. Snyder. Representative Snyder. Soper. Sullivan. Tipper. Representative Tipper. Representative Tipper is excused. Titone. Valdez A. Valdez D. Van Bever. Van Winkle.
Here.
Weissman. Will. Williams. Representative Williams. Woodrow. Woog. Young. And Mr. Speaker.
59 present, 6 excused. We have a quorum. Representative Ricks.
Mr. Speaker, I move that the Journal of Wednesday, May 19, 2021 be approved as corrected by the Chief Clerk.
Members, you have heard the motion that the journal be approved as corrected by the Chief Clerk. All those in favor say aye.
Aye.
All those opposed, no.
No!
Wow, that was really good. The ayes clearly have it. The motion is approved. Announcements and introductions. Representative Woodrow. We have a tribute, members. Please direct your attention to Representative Woodrow. Mr. Gregorio.
State of Colorado. The House of Representatives convened in the 73rd General Assembly hereby extends sincere condolences and expressions of sympathy to the Tebow family on the passing of Charlene Tebow. The members of the Colorado House of Representatives wish to offer our sincere condolences on the passing of Charlene Tebow. Born in Denver, Colorado, Charlene dedicated her life to helping the people of Colorado through her political work and volunteerism. As the niece of former Colorado Secretary of State George Baker, she grew up understanding the importance of civic engagement. Charlene served in her House district as a precinct committee person and routinely volunteered for numerous candidate and issue campaigns. She directly worked with various legislators on issues of education, business, healthcare, and many issues that Coloradans face daily. Charlene has also continued to instill the principles of political participation in her 3 children, 2 of which, Michelle Fry and Patrick Tebow, worked for several state House and Senate members. Just before her sudden and unexpected passing, Charlene completed her MBA while working with students as an educator in alternative needs and special education at Smith Elementary. Charlene will always be known and remembered for her warm, welcoming demeanor and always opening her home and heart to those in need. As a result, we celebrate the numerous accomplishments and contributions of Charlene Tebow to the people of Colorado. On request of Representative Stephen Woodrow, given this 20th day of May, 2021, State Capitol, Denver.
Good morning, members. Thank you so much. Every one of our communities has suffered horrible losses this past year, and I just want to take a moment to honor a very special member of my community, Charlene Tebow, who passed away this March, 2 days before what would have been her 68th birthday. She was an absolute force, a single mother of 3, including her son Matthew, her daughter Michelle, who's here today, along with her son Patrick, who's here today celebrating his birthday, no less. She completed her undergraduate degree at age 60 and her MBA at age 67. She had an impressive career in real estate and worked with alternative needs children in public schools, something that's been described as her true passion. Her generosity was simply legendary. I'm honored to be joined today, members, not only by members of her family, but with Senator James Coleman, former Representatives Javon Melton, and Joe Salazar. You were taken too soon, Char, and you will be missed. Thank you, colleagues.
Thank you very much, Representative Woodrow, and to the family, we send our most sincere condolences. Thank you for joining us. And to our former colleagues, welcome back to the floor. Sorry it's such unfortunate circumstances. Any other announcements and introductions? Representative Byrd.
Thank you, Madam Majority Leader. So members, guess what? It is Thursday, and it is not only finance, it is super finance today. So first important thing to note is we will be meeting in the Old State Library today, and we have a packed calendar. So take note, today we will be hearing House Bill 1317, Senate Bill 250, House Bill 1175, Senate Bill 94, House Bill 1058 upon adjournment. So one more time, just to reiterate, in light of our heavy calendar, we'll be limiting witness testimony on each bill to a half hour for proponents and half hour for opponents on each bill. So if you have questions, please feel free to follow up with me. But again, Finance, Old State Library, meeting upon adjournment.
Representative McCormick.
Thank you, Madam Majority Leader. Super finance sounds super fun. But we have an Agriculture, Livestock, and Water Committee meeting upon adjournment where we will be hearing Senate Bill 237 and House Bill 1301. We'll see you whenever that is. Thank you.
Representative Cutter and Representative Bradfield. Hold on one moment. Members, I know that there's a lot of commotion on the floor and hello and greetings to be had, but we are having some announcements, so kind of try to pay attention, please. Representative Cutter.
Thank you, Madam Majority Leader. It's an honor to serve with you.
Honor to serve with you.
Guess what's more fun than super finance? Anybody? Anybody? Bringing your clothes. Yeah, no, Shan. No, Rep Bird. No. It's bringing your clothes for people to get jobs, right? So don't forget.
Representative
Remember
Bradfield.
all those hangers that used to be empty in your closet that are now filled with gently used, but oh my land, I am sick and tired of it. Take them off those hangers and bring them in because there are people who can use those clothes. Thank you very much.
See you tomorrow afternoon.
Thank you both. Are there any other announcements and interjections? Representative Kennedy.
Thank you, Madam Speaker Pro Tem. Members of House, State, Civic, Military, and Veterans Affairs will be meeting upon adjournment in LSBA to hear House Bill 1240, Senate Bill 148, House Bill 1111, and House Bill 1316.
Thanks, Representative Kennedy. Representative McLaughlin.
Thank you. I'm super glad I'm not on super finance, but we do have a super education committee today. We are listening to 4 Senate bills: Senate Bill 202, 29, 116, and 185. We'll see you there. Thanks.
Representative Roberts.
Thank you, Mr. Speaker. Good morning. Business Affairs and Labor Committee, we are meeting this afternoon. We have 4 bills on the agenda. I'm adding a bill for action only that is not on the printed calendar, but we will go in order. 1229 for action only, then we will have 1319, then Senate Bill 95, and then we are adding Senate Bill 173 for action only at the end of the calendar.
Representative Harrod.
Thank you, Mr. Speaker. Members, we will have an Appropriations Committee tomorrow morning at 7:30 a.m. Your canaries should be on your desk this afternoon.
Thank you, Representative Harrod. Any further announcements or introductions? Seeing none. The next order of business is third reading of bills, final passage. Mr. Gregorio, please read the title to House Bill 1174.
House Bill 1174 by Representative Hooton, also Senator also Senator Story, concerning the transfer of the Capital Construction Fund of excess proceeds from the issuance of a lease purchase agreement under Senate Bill 20-219 that are initially credited to the Emergency Controlled Maintenance Account.
Majority Leader Escar.
Thank you, Mr. Speaker. I move House Bill 1174 on third reading, final passage.
The question before us is the adoption of House Bill 1174 on third reading and final passage. Seeing no further discussion, Mr. Gregorio, please open the machine, and members, please proceed to vote. For those participating remotely, Representative Van Winkle, how do you vote?
No.
Representative Van Winkle votes no. Representative Neville, how do you vote?
No.
Representative Neville votes no. Representative Jackson, how do you vote?
Yes.
Representative Jackson votes yes. Representative Harrod, how do you vote?
Yes.
Representative Harrod votes yes. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Bockenfeld and Williams. Representative Williams is excused. Please close the machine. With 42 aye votes, 19 no votes, and 4 excused, House Bill 1174 is adopted. Co-sponsors. Please close the machine. Mr. Gregorio, please read the title of House Bill 1233.
House Bill 1233 by Representatives Roberts and Will, also Senators Donovan and Winter, concerning modifications to the requirements for claiming an income tax credit for the donation of a perpetual conservation easement in connection therewith, making an appropriation.
Majority Leader Escar.
Thank you, Mr. Speaker. I move House Bill 1233 on third reading, final passage.
The question before us is the adoption of House Bill 1233 on third reading and final passage. Seeing no further discussion, Mr. Gregorio, please open the machine, and members, please proceed to vote. Representative Van Winkle, how do you vote? One more time.
Yes.
Representative Van Winkle votes yes. Representative Neville, how do you vote?
No.
Representative Neville votes no. Representative Jackson, how do you vote?
Yes.
Representative Jackson votes yes. Representative Harrod, how do you vote?
Yes.
Representative Harrod votes yes. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Please close the machine. With 51 aye votes, 10 no votes, and 4 excused, House Bill 1233 is adopted. Co-sponsors. Please close the machine. Mr. Gregorio, please read the title of House Bill 1280.
House Bill 1280 by Representatives Woodrow and Gonzalez Gutierrez, also Senators Lee and Rodriguez, concerning measures to assist defendants in securing release from jail through the bonding process and in connection therewith, making an appropriation.
Majority Leader Escar.
Thank you, Mr. Speaker. I move House Bill 1280 on third reading, final passage.
The question before us is the adoption of House Bill 1280 on third reading and final passage. Seeing no further discussion, Mr. Gregorio, please open the machine, and members, please proceed to vote. Representative Van Winkle, how do you vote?
No.
Representative Van Winkle votes no. Representative Neville, how do you vote?
No.
Representative Neville votes no. Representative Jackson, how do you vote?
Yes.
Representative Jackson votes yes. Representative Harrod, how do you vote?
Yes.
Representative Harrod votes yes. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Hooton and Callan. Please close the machine. With 39 aye votes, 22 no votes, and 4 excused, House Bill 1280 is adopted. Co-sponsors. Representative Jackson, Harrod, co-sponsor. Please close the machine. Mr. Gregorio, please read the title of the House Bill 1289.
House Bill 1289 by Representatives
Sorry,
Kennedy
Mr.
and
Gregorio.
Baisley.
Oh, yeah, no, I'm sorry. Sorry.
House Bill 1289 by Representatives Kennedy and Baisley, also Senators Bridges and Priola, concerning broadband deployment and in connection therewith, codifying the Colorado Broadband Office and the Office of Information Technology, creating the Digital Inclusion Grant Program, the Broadband Stimulus Grant Program, and the Interconnectivity Grant Program, and making an appropriation.
Majority Leader Escar.
Thank you, Mr. Speaker. I move House Bill 1289 on third reading, final passage.
The question before us is the adoption of House Bill 1289 on third reading and final passage. Is there any further discussion? Seeing none, Mr. Gregorio, please open the machine, and members, please proceed to vote. Representative Van Winkle, how do you vote?
No.
Representative Van Winkle votes no. Representative Neville, how do you vote?
No.
Representative Neville votes no. Representative Jackson, how do you vote?
Yes.
Representative Jackson votes yes. Representative Harrod, how do you vote?
Yes.
Representative Harrod votes yes. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Catlin. Please close the machine. With 49 aye votes, 13 no votes, and 3 excused, House Bill 1289 is adopted. Co-sponsors. Representative McLaughlin, co-sponsor. Representative Jackson, co-sponsor. Representative Harrod, co-sponsor. Please close the machine. Mr. Gregorio, please read the title of House Bill 1290.
House Bill 1290 by Representatives Escar and Will, also Senators Fenberg and Rankin, considering funding to provide just transition for coal transition workers and coal transition communities in connection therewith, making an appropriation.
Majority Leader Escar.
Thank you, Mr. Speaker. I move House Bill 1290 on third reading, final passage.
The question before us is the adoption of House Bill 1290 on third reading and final passage. Seeing no further discussion, Mr. Gregorio, please open the machine and members, please proceed to vote. Representative Van Winkle, how do you vote?
No.
Representative Van Winkle votes no. Representative Neville, how do you vote?
No.
Representative Neville votes no. Representative Jackson, how do you vote?
Yes.
Representative Jackson votes yes. Representative Harrod, how do you vote?
Yes.
Representative Harrod votes yes. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Please close the machine. With 48 aye votes, 15 no votes, and 2 excused, House Bill 1290 is adopted. Co-sponsors. Representative McLaughlin, Jackson, Harrod, co-sponsor. Please close the machine. Mr. Gregorio, please read the title to House Bill 1065.
House Bill 1065 by Representatives Ortiz and Carver, also Senators Garcia and Gardner, concerning the authority of a private employer to adopt a veteran's preference employment policy when hiring new employees.
Majority Leader Escar.
Thank you, Mr. Speaker. I move House Bill 1065 on third reading, final passage.
Question before us is the adoption of House Bill 1065 on third reading and final passage. Mr. Gregorio, please open the machine and members, please proceed to vote. Representative Van Winkle, how do you vote?
Yes.
Representative Van Winkle votes yes. Representative Neville, how do you vote?
Yes.
Representative Neville votes yes. Representative Jackson, how do you vote?
Yes.
Representative Jackson votes yes. Representative Harrod, how do you vote?
Yes.
Representative Harrod votes yes. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Please close the machine. With 64 aye votes, 0 no votes, and 1 excuse, House Bill 1065 is adopted. Co-sponsors. Representative McLaughlin, co-sponsor. Representative Van Winkle, co-sponsor. Representative Harrod, co-sponsor. Representative Jackson, co-sponsor. Please close the machine. Mr. Gregorio, please read the title of House Bill 1189.
House Bill 1189 by Representatives Benavides and Valdez, also Senators Gonzalez and Moreno, concerning additional public health protections in relation to the emission of air toxics.
Majority Leader Escar.
Thank you, Mr. Speaker. I move House Bill 1189 on third reading, final passage.
The question before us is the adoption of House Bill 1189 on third reading and final passage. Seeing no further discussion, Mr. Gregorio, please open the machine and members, please proceed to vote. Representative Van Winkle, how do you vote?
No.
Representative Van Winkle votes no. Representative Neville, how do you vote?
No.
Representative Neville votes no. Representative Jackson, how do you vote?
Yes.
Representative Jackson votes yes. Representative Harrod, how do you vote? Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Harrod, how do you vote? Representative Harrod is excused with a $5 fine. Please close the machine. With 40 aye votes, 23 no votes, and 2 excused, House Bill 1189 is adopted. Co-sponsors. Representative Jackson, co-sponsor. Please close the machine. Mr. Gregorio, please read the title to House Bill 1254.
House Bill 1254 by Representatives Valdez A. and Larson, also Senators Winter and Priola, concerning regulation related to the ownership of a vehicle.
Majority Leader Escar.
Thank you, Mr. Speaker. I move House Bill 1254 on third reading, final passage.
The question before us is the adoption of House Bill 1254 on third reading and final passage. See no further discussion. Mr. Gregorio, please open the machine, and members, please proceed to vote. Representative Van Winkle, how do you vote?
No.
Representative Van Winkle votes no. Representative Neville, how do you vote?
No.
Representative Neville votes no. Representative Jackson, how do you vote?
Yes.
Representative Jackson votes yes. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Please close the machine. With 44 aye votes, 19 no votes, and 2 excused, House Bill 1254 is adopted. Co-sponsors. Please close the machine. Mr. Gregorio, please read the title to House Bill 1281.
House Bill 1281 by Representatives Cutter and Will, also Senator Pedersen, concerning the creation of the Community Behavioral Health Disaster Preparedness and Response Program in the Department of Public Health and Environment to ensure behavioral health is adequately represented within disaster preparedness and response efforts across the state.
Majority Leader Escar.
Thank you, Mr. Speaker. I move House Bill 1281 on third reading, final passage.
The question before us is the adoption of House Bill 1281 on third reading and final passage. See no further discussion. Mr. Gregorio, please open the machine, and members, please proceed to vote. Representative Van Winkle, how do you vote?
No.
Representative Van Winkle votes no. Representative Neville, how do you vote?
No.
Representative Neville votes no. Representative Jackson, how do you vote?
Yes.
Representative Jackson votes yes. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Please close the machine. With 43 aye votes, 20 no votes, and 2 excused, House Bill 1281 is adopted. Co-sponsors. Representative Jackson, McLaughlin, co-sponsor. Please close the machine. Mr. Gregorio, please read the title of the House Bill 1283.
House Bill 1283 by Representatives Ricks and Hooton, also Senator Fields, concerning measures to address consumer protection concerns regarding vehicle towing.
Majority Leader Escar.
Thank you, Mr. Speaker. I move House Bill 1283 on third reading, final passage.
The question before us is the adoption of House Bill 1283 on third reading and final passage. Seeing no further discussion, Mr. Gregorio, please open the machine, and members, please proceed to vote. Representative Van Winkle, how do you vote?
No.
Representative Van Winkle votes no. Representative Neville, how do you vote?
No.
Representative Neville votes no. Representative Jackson, how do you vote?
Yes.
Representative Jackson votes yes. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Please. Please close the machine. With 40 aye votes, 23 no votes, and 2 excused, House Bill 1283 is adopted. Co-sponsors. Representative Jackson, co-sponsor. Please close the machine. Mr. Gregorio, please read the title of the House Bill 1282.
House Bill 1282 by Representative Weissman, also Senator Gonzalez, concerning additional consumer protections resulting from the regulation of mortgage servicers.
Majority Leader Escar.
Thank you, Mr. Speaker. I move House Bill 1282 on third reading, final passage.
The question before us is the adoption of House Bill 1282. Representative Pelton.
Thank you, Mr. Speaker. I still have some issues with this bill, so I'd ask that it be read at length.
That motion is in order. We will set that up.
First regular session, 73rd General Assembly, State of Colorado, engrossed. This version includes all amendments adopted on second reading in the House of Introduction. LLS No. 21-0508.02 Thomas Morris X 4218 House Bill 21 to 1282. House Committees, Senate Committees, Business Affairs and Labor, Finance, Appropriations. A bill for an act. 101 concerning additional consumer protections resulting from 102 the regulation of mortgage servicers, and, in 103 connection therewith, making an appropriation. Bill summary. Note, this summary applies to this bill as introduced and does not reflect any amendments that may be subsequently adopted. If this bill passes third reading in the House of Introduction, a bill summary that applies to the re-engrossed version of this bill will be available at http://leg.colorado.government. The bill subjects mortgage servicers to regulation by an Assistant Attorney General, including the requirements of notification, record keeping, reporting, examinations, inspections, and enforcement. A violation of the requirements is an unfair or deceptive trade practice. House amended second reading May 19, 2021. House sponsorship Weissman. Senate sponsorship Gonzalez. Shading denotes House amendment. Double underlining denotes Senate amendment. Capital letters or bold and italic numbers indicate new material to be added to existing statute. Dashes through the words indicate deletions from existing statute. 1. Be it enacted by the General Assembly of the State of Colorado. 2. Section 1. In Colorado Revised Statutes, add Article 21 to Title 3.5 as follows. For Article 21.5 Colorado Non-Bank Mortgage Servicers Act 65-21-101. Short title. The short title of this Article 21 is the 7 Colorado Non-Bank Mortgage Servicers Act. 85-21-102. Scope of Article. Unless otherwise provided in this 9 Article 21, this Article 21 applies to any person engaged in 10 servicing a residential mortgage loan secured by a dwelling or 11 residential real property located in this state. 12.5-21-103. Definitions. As used in this Article 21, unless the 13 context otherwise requires. 14. 1. Administrator means the administrator of the 15 Uniform Consumer Credit Code, Articles 1 to 9 of this Title 5, 16 designated pursuant to Section 5-6-103. 17. 2. Borrower means an individual obligated to repay a 18 residential mortgage loan. 19. 3. Loans held for sale means loans originated and held. 20. For sale for up to 364 days after each. 21. Loans origination. 22. 4. Mortgage servicer means a person, wherever 23 located, that is responsible for servicing a Colorado residential 24 mortgage loan. A mortgage servicer includes a person that 25 makes payments to a borrower under a reverse mortgage as 26 defined in Section 1138-102. 4. A mortgage servicer does not. -2 1282. 1 include. 2. A supervised financial organization as defined in 3 Section 5-1-301. 45. 4. B. A mortgage loan originator regulated by the Division 5 of Real Estate or American Samoa defined in Section 12-10-702. 14. A. Or a 6 mortgage company regulated by the Division of Real Estate or 7 as defined in Section 12-10-702. 12. Except that a mortgage loan 8 originator or mortgage company that also services a 9 residential mortgage loan is a mortgage servicer. 10. C. A federal agency or department. 11. D. A collection agency as defined in Section 5-16-103. 3. 12. That is licensed pursuant to Section 5-16-120 or is exempt from 13 licensure under Section 5-16-103. 3. E. And whose mortgage debt. 14. Collection business involves collection of residential mortgage. 15. Loans obtained by the collection agency after default, except 16. That a collection agency that also services residential. 17. Mortgage loans assigned to the collection agency before 18 default is a mortgage servicer. 19. E. An agency, instrumentality, or political subdivision of. 20. This state. 21. F. A supervised lender as defined in Section 5-1-301. 46. 22. Except that a supervised lender, other than a supervised. 23. Financial organization as defined in Section 5-1-301. 45. That 24 also services residential mortgage loans is a mortgage servicer. 25. G. A small servicer that services fewer than 526,000 residential mortgage loans in any calendar year. 27. Exclusive of loans held for sale, as determined by the -3 1282. 1 administrator, who shall apply the criteria in 12 CFR 1026.412, E, 4, 3, or any successor regulation. 3, H, a person that the administrator designates by rule or for order as exempt. These exemptions are limited to nonprofit 5 organizations, government agencies, or other entities whose 6 primary business is not to service mortgages and that seek to 7 promote affordable housing or financing. 8. I, an originator or servicer that utilizes a subservicer to 9 carry out the administrative functions of servicing a mortgage. 10 unless the subservicer is acting at the direction of the 11 originator or servicer. Or 12. J, a person that services loans held for sale. 13. 5. Notifier means a person required to notify the 14 administrator of the person's activities as a mortgage servicer. 15. Pursuant to this Article 21. 16. 6. Record means information that is inscribed on a 17 tangible medium or that is stored in an electronic or other 18 medium and is retrievable in perceivable form. 19. 7. Residential mortgage loan means a loan that is 20 primarily for personal, family, or household use and that is 21 secured by a mortgage, deed of trust, or other equivalent. 22. Consensual security interest on a dwelling or residential real. 23. Property upon which is constructed or intended to be. 24. Constructed a dwelling as defined by Section 5-1-301. 18. 25. 8. Servicing means receiving any scheduled periodic 26 payments from a borrower pursuant to the terms of a 27 residential mortgage loan, including amounts for escrow. -4 1,282. 1 accounts, and making the payments to the owner of the loan or to other third parties of principal and interest and such other 3 payments with respect to the amounts received from the 4 borrower as may be required pursuant to the terms of the 5 residential mortgage servicing loan documents or servicing 6 contract. In the case of a reverse mortgage, servicing includes 7 making payments to the borrower. 85-21-104. Notification required. On and after January 31st, 2022, a person shall not act as a mortgage servicer, directly or 10 indirectly, without notifying the administrator pursuant to 11 Section 5-21-105. 12-5-21-105. Notification by mortgage servicers, rules. 13. 1. Notification. A person acting as a mortgage servicer must 14 notify the administrator and pay the fee prescribed in Section 15-5-21-106 within 30 days after commencing servicing in the 16th state, and, thereafter, on or before January 31st of each year. The 17. Notification must state the notifier's legal name and all trade. 18. Names used, the address of the notifier's principal office, which may 19th be outside this state, and such other information as the 20 administrator may require. 21. B. With every renewal notification or at a date 22 prescribed by rule by the administrator, each notifier shall 23 submit an annual report relating to mortgage servicing by the 24 notifier in the form prescribed by the administrator. 25. Information contained in annual reports is confidential, is not 26 subject to disclosure pursuant to Part 2 of Article 72 of Title 24, 27, and may be published only in composite form. -5 1282. 1. 2. Records retention, records request. A mortgage 2 servicer shall maintain adequate records for not less than 3 years following the final payment on the residential mortgage 4 loan, transfer of the mortgage servicing rights, or the 5 assignment of the loan, whichever occurs first. Upon request by 6 the administrator, a mortgage servicer shall make the records 7 available or shall send the records to the administrator by 8 registered or certified mail, return receipt requested, or by any 9 express delivery carrier that provides a dated delivery receipt, 10 not later than 30 business days after requested by the 11 administrator or other method of delivery as agreed to in 12 writing by the administrator, including secure electronic 13 transmission. Upon a notifier's request, the administrator may 14 grant the notifier additional time to make the records 15 available or to send the records to the administrator. 16. B. Every mortgage servicer shall maintain records in 17. Conformity with this Article 21, rules adopted pursuant to this 18 Article 21, and generally accepted accounting principles, and 19. Practices in a manner that will enable the administrator to 20 determine whether the servicer is complying with this Article 21. 21. A mortgage servicer's record-keeping system is sufficient if the 22 servicer makes the required information reasonably available. 23. The records need not be kept in the place of business where 24 mortgage loans are serviced if the administrator is given free 25 access to the records wherever located. 26. 5-21-106. Fees. 1. A notifier shall pay the following 27 non-refundable fees established by the administrator pursuant. -6 1282. 1. To subsection 3 of this section. 2. A. An initial notification fee, and 3. B. An annual notification fee. 4. 2. The administrator shall transmit the fees to the State 5 Treasurer, who shall credit them to the Uniform Consumer 6 Credit Code Cash Fund created in Section 5-6-204, 1. 7. 3. The administrator shall set the fees required by 8 subsection 1 of this section in an amount estimated to cover 9. The administrator's costs in implementing this Article 21 and may 10 periodically reduce or increase the amount of 1 or more of 11 the fees if necessary pursuant to Section 24-75-402, 3, and 4. To 12 reduce the uncommitted reserves of the Uniform Consumer 13 Credit Code Cash Fund. 14-5-21-107. Federal laws. 1. A mortgage servicer shall 15 comply with all federal laws and regulations applicable to 16 mortgage servicers for their mortgage servicing activities, 17 including 18. A. The Federal Real Estate Settlement Procedures Act. 19 of 1974, 12 U.S.C. SEC 2601 ETSEQ, as amended, and 20. B. The Truth in Lending Act, 15 U.S.C. SEC 1601 ETSEQ, 21 as amended. 22. 2. In addition to any other remedies provided by law, a 23 violation of any federal law or regulation that is covered by 24 subsection 1 of this section shall be deemed a violation of this 25 Article 21. 26. 3. All financial responsibility requirements of this 27 Article 21 shall be presumed to be met if a mortgage servicer is. 7282. 1. Currently approved to service loans by the Federal National 2 Mortgage Association, Federal Home Loan Mortgage 3 Corporation, or Government National Mortgage Association, or 4 if it meets prudential standards established by the Conference 5 of State Bank Supervisors. 65-21-108. Powers and duties of the Administrator. Rules. 7. 1. The Administrator may conduct investigations and aid examinations as follows. 9. A. For purposes of general or specific inquiry, or 10. Investigation to determine compliance with this Article 21. The 11. Administrator may access, receive, and use any records, or 12. Information belonging to a notifier or person subject to this 13 Article 21 who may have failed to notify the Administrator. 14. Pursuant to Section 5-21-104, including criminal, civil, and 15. Administrative history information. Personal history, and 16. Experience information, including independent credit reports. 17. Obtained from a consumer reporting agency described in Section 18603 P of the Federal Fair Credit Reporting Act, 15 U.S.C. SEC 1916-81A, as amended, and any other records or information the 20 Administrator considers relevant to the inquiry, or 21 investigation regardless of the location, possession, control, or 22 custody of the records or information. 23. B. The Administration may initiate an investigation, or 24 examination where there is reason to believe that there is a 25 potential violation that risks consumer harm, where a person 26 who may be subject to this article may 21st have failed to notify 27 the Administrator, or based on a substantiated complaint. They. 81282. 1 Administrator may review, investigate, or examine any notifier to or person subject to this Article 21 as often as necessary in 3 order to carry out the purposes of this Article 21. The 4 Administrator may direct, subpoena, or order the attendance of 5 and examine under oath any person whose testimony may be 6 required about the residential mortgage loan, residential 7 mortgage loan servicing, or the business or subject matter of an 8 examination or investigation, and may direct, subpoena, or order 9 the person to produce records the Administrator considers 10 relevant to the inquiry. Nothing limits the scope of the 11 Administrator's authority to review and investigate potential 12 violations or harm discovered in the course of an investigation. 13. C. I. In making an examination or investigation. 14. Authorized by this section, the Administrator may control. 15. Access to any records of the notifier or person under. 16. Examination or investigation. The Administrator may take. 17. Possession of the records or place a person in exclusive charge. 18. Of the records in the place where they are usually kept. 19. 2. During the period of control, a person may not remove 20 or attempt to remove any of the records except pursuant to a 21 court order or with the written consent of the Administrator. 22. Unless the Administrator has reasonable grounds to believe the 23 records of the notifier or person have been, or are at risk of 24 being, altered, or destroyed for purposes of concealing a 25 violation of this Article 21, the notifier or owner of the records may 26th have access to the records as necessary to conduct its 27 ordinary business affairs. 91282. 1. 2. In order to carry out the purposes of this section, the 2 Administrator may, 3. A. Retain attorneys, accountants, or other professionals for and specialists as examiners, auditors, or investigators to 5. Conduct or assist in conducting examinations or investigations. 6. B. Enter into agreements or relationships with other 7 government officials or regulatory associations in order to aid improve efficiencies and reduce regulatory burden by sharing 9 resources, standardized or uniform. Methods or procedures, and 10 records or information obtained under this section. 11. C. Use, hire, contract for, or employ publicly or 12 privately available analytical systems, methods, or software. 13. To examine or investigate the notifier or person subject to this 14 Article 21. 15. D. Accept and rely on examination or investigation. 16. Reports made by other government officials within or outside 17 this state. And 18. E. Accept audit reports made by an independent certified. 19. Public accountant for the notifier or person subject to this. 20. Article 21. In the course of that part of the examination covering 21 the same general subject matter as the audit, and may 22 incorporate the audit report in a report of examination, report 23 of investigation, or other writing of the Administrator. 24. 3. A person subject to investigation or examination under 25 this section may not knowingly withhold, abstract, remove, 26 mutilate, or destroy any records or other information relating 27 to information regulated under this Article 21. 10-1282. 1. 4. Whenever it appears to the Administrator that a 2 person has violated, is violating, or is about to violate this 3 section or a rule adopted pursuant to this Article 21, or that a 4 notifier or an owner, director, officer, member, partner, 5 shareholder, trustee, employee, or agent of the notifier has 6 committed fraud, engaged in dishonest activities, or made a 7 misrepresentation, the Administrator may take action against 8 the person or notifier in accordance with this Article 21.9. 5. The Administrator shall adopt rules as necessary to 10 implement this Article 21. 11-12-5-21-109. Application of administrative procedures. except as 13 otherwise provided in this Article 21. Sections 24-4-102 to 1424-4-106 apply to and govern all rules promulgated and all 15 administrative action taken by the administrator pursuant to 16 this Article 21, except that Section 24-4-104, 3, does not apply to 17 any such action. 18.5-21-110. Administrative enforcement orders. 1. After 19 notice and hearing, the administrator may order a mortgage 20 servicer or a person acting in the mortgage servicer's behalf to 21 cease and desist from engaging in violations of this Article 21 or 22 any rule or order lawfully made pursuant to this Article 21. 23. The order issued by the administrator may also require the 24 mortgage servicer or person to make refunds to individuals of 25 overcharges or other damages suffered by the borrower. 26. Under this Article 21 and a civil penalty in the amounts stated 27 and 12 U.S.C. SEC 5565 C 2, all or part of which may be 11 1282. 1 specifically designated for consumer and creditor educational 2 purposes. When seeking civil penalties, the administrator shall 3 consider the mitigating factors in 12 U.S.C. SEC 5565 C 3. 4. 2. A mortgage servicer aggrieved by an order of the 5 administrator may obtain judicial review of the order in the 6 Colorado Court of Appeals. The administrator may obtain in 7 order of the court for enforcement of the administrator's order 8 in the district court under section 24-4-106. All proceedings 9 under this section are governed by sections 24-4-105 and 1024-4-106. 11.5-21-111. Assurance of discontinuance. If it is claimed that 12A person has violated this Article 21, the administrator may 13 accept an assurance in writing that the person will not engage 14 in the conduct in the future. The assurance may also require the 15 person to make refunds to individuals of unlawful charges. 16 under this Article 21, pay a penalty authorized in section 17.5-21-110, all or part of which may be specifically designated for 18 consumer and creditor educational purposes, and reimburse the 19 administrator for the administrator's reasonable costs 20 incurred in investigating the conduct. If a person giving in 21 assurance of discontinuance fails to comply with its terms, the 22 assurance is evidence that prior to the assurance, that person 23 engaged in the conduct described in the assurance. 24.5-21-112. Injunctions. The administrator may bring a civil 25 action to restrain a person from violating this Article 21 or 26 rules promulgated pursuant to this Article 21 and for other 27 appropriate relief, including such orders or judgments as may be. 12.1282. 1 necessary to completely compensate or restore to the 2 individuals' original position any individual affected by the 3 violation. The administrator may also apply for a temporary 4 restraining order or a preliminary injunction against a 5 respondent pending final determination of proceedings. No bond 6 or other security is required of the administrator before relief. 7 under this section may be granted. 85-21-113. Civil actions by the administrator. 1. The 9 administrator may bring a civil action against a mortgage 10 servicer or any other person for any violations of this Article 1121. An action may relate to transactions with more than 112 individual. The court may order a mortgage servicer to refund 13 to individuals overcharges or other damages suffered by the 14 borrower collected in violation of this Article 21 and may also 15 assess civil penalties against the mortgage servicer as set forth 16 in Section 5-21-110. If the administrator prevails in an action. 17 brought under this section, the administrator may recover 18 reasonable costs in investigating and bringing the action and may 19 recover reasonable attorney fees. When determining 20 whether to seek civil penalties under this section, the 21 administrator shall consider whether the Federal Consumer 22 Financial Protection Bureau has imposed civil penalties on the 23 same servicer for the same violation and any other mitigating 24 factors, in order to avoid duplicative civil penalties. If the 25 Federal Consumer Financial Protection Bureau has been awarded 26 and paid civil penalties based on a particular act or omission or 27 a series of acts or omissions, civil penalties under section 13-1282. 15-21-110 that are based on the same acts or omissions are to reduced by the same amount or to $1,503 per violation, whichever is less. The administrator shall, to the extent possible, coordinate with the Federal 5 Consumer Financial Protection Bureau before taking action in 6 order to avoid duplication of investigations and penalties. 7 unless the administrator's investigation or penalties relate to 8 acts or omissions separate from the Federal Consumer Financial 9 Protection Bureau activities. 10. 2. Nothing in this Article 21, 11, a, creates a private right of action, or 12, b, affects any remedy that a borrower may have. 13 pursuant to law other than this Article 21. 14.5-21-114. Limitations. Notwithstanding Article 80 of Title 15-13, all actions brought under this Article 21 must be commenced 16 within 4 years after the date on which any violation of this 17 Article 21 occurred or the date on which the last in a series of 18 the acts or practices occurred or within 4 years after the 19. Plaintiff discovered or in the exercise of reasonable diligence 20 should have discovered the occurrence of a violation of this 21 Article 21, except that the period of limitation provided in this 22 section may be extended for a period of 1 year if the plaintiff 23 proves that failure to timely commence the action was caused 24 by the defendant engaging in conduct calculated to induce the 25 plaintiff to refrain from or postpone the commencement of the 26 action. 27.5-21-115. Confidential information. 1. The Administrator. Dash 14 1282. 1 shall not make public the name or identity of a person whose two acts or conduct the administrator investigates or examines. 3 pursuant to this Article 21 or the facts disclosed in the 4 investigation or examination. 5. 2. The administrator may disclose notification records 6 provided to the administrator and other contents of the 7 records maintained pursuant to this Article 21, but the 8 administrator shall not make public the confidential 9 information contained in the records. 10. 3. The restrictions on the disclosure of information in 11 subsections 1 and 2 of this section do not apply to disclosures 12 by the administrator in actions or enforcement proceedings 13 pursuant to this Article 21. 14.5-21-116. Reporting. 1. The Department of Law shall 15 include in its annual presentations held pursuant to Section 16.2-7-203 updates concerning the administration of this Article 21. 17 including 18. A. Complaints data, enforcement actions, and other. 19. Relevant regulatory data, and 20. B. The use of fees collected by the administrator 21 pursuant to this Article 21. 22-23 Section 2. In Colorado Revised Statutes 13-4-102, add 24, 2, NN, as follows, 2513-4-102. Jurisdiction. 2. The Court of Appeals has initial 26 jurisdiction to 27, NN, review final decisions or orders of the administrator. 15-1282. 1 as provided in Article 21 of Title 5. 2 Section 3. Appropriation. For the 2021-22 state fiscal year, $351,783 is appropriated to the Department of Law for use by Consumer for Protection. This appropriation is from the Uniform Consumer Credit Code 5 Cash Fund created in Section 5-6-204, 1, CRS, and is based on an 6 assumption that the Department will require an additional 0.5 FTE. To 7 implement this Act, the Department may use this appropriation for 8 Consumer Credit Unit. 9 Section 4. Act subject to petition. Effective date, 10 applicability. 1. This Act takes effect January 1, 2022, except that, if a 11 referendum petition is filed pursuant to Section 1, 3, of Article V of the 12 state constitution against this Act or an item, section, or part of this Act 13 within the 90-day period after final adjournment of the General 14 Assembly, then the Act, item, section, or part will not take effect unless 15 approved by the people at the general election to be held in November 16, 2022 and, in such case, will take effect on the date of the official 17 declaration of the vote thereon by the Governor. 18. 2. This Act applies to conduct occurring on or after the applicable 19 effective date of this Act. 16-1282.
Representative Pelton.
Thank you, Mr. Speaker, and I do appreciate that bill being read linked because now it really solidified in my mind just what this bill is, and I can vote my conscience, so I'd ask for a no vote.
Is there any further discussion? Seeing none, the question before us is the adoption of House Bill 1282 on third reading and final passage. Seeing no further discussion, Mr. Gregorio, please open the machine and members please proceed to vote. Representative Van Winkle, how do you vote?
No.
Representative Van Winkle votes no. Representative Neville, how do you vote?
No.
Representative Neville votes no. Representative Jackson, how do you vote?
Yes.
Representative Jackson votes yes. Representative Harrod, how do you vote?
Yes.
Representative Harrod votes yes. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Please close the machine. With 42 aye votes, 22 no votes, and 1 excuse, House Bill 1282 is adopted. Co-sponsors. Representative Jackson, Harrod, co-sponsor. Please close the machine. The next order of business is general order, second reading of bills. Representative Kipp. You have heard the motion. Seeing no objection, Representative Kipp will take the chair.
The committee will come to order. With your unanimous consent, the bills will be read by title unless there is a request for reading a bill at length. Committee reports are printed and in your bill folders. Floor amendments will be shown on the screen and in your iPads. The bills will be laid over upon motion of the majority leader. The court rule is relaxed. Okay, we are starting with HB 21-1269. Mr. Gregorio, can you please read the title of HB 21-1269?
House Bill 1269 by Representatives Hooten and Basenecker, also Senator Donovan, concerning an investigation by the Public Utilities Commission to evaluate the parameters of an energy policy allowing communities in Colorado that are served by an investor-owned electric utility to choose alternative wholesale electricity suppliers.
Representative Hooten.
Thank you, Madam Chair. I move House Bill 1269 with the Appropriations Committee report and the Energy and Environment Committee report.
Okay, to the Energy and Environment Committee report.
Thank you, members.
Oh, sorry, to the Appropriations Committee report. My apologies.
Yes, members, in Appropriations, Representative Bosniak and I were awarded the best joke, and we received a prize of a box of Girl Scout cookies, which we shared with anyone in the chamber who was interested in having a cookie.
That was
you.
very generous of you. I'm sorry, the motion, sorry, I am not awake this morning, apparently. The motion, on the floor, we have adoption of the committee report for appropriations for HB 1269. All in favor, please say aye.
Aye.
All opposed? Okay, the committee report is adopted. Next, we have the Energy Environment Committee report. Would you please explain the committee report to us?
Yes, thank you, Madam Chair. In the Energy and Environment Committee, we did adopt an amendment that at the request of the Colorado Energy Office that adds a question about the impacts of resource adequacy and reliability to the list of questions being considered by the Public Utilities Commission in the open docket.
Okay, thank you. The motion here is, or the...
Is there any further discussion?
I'm sorry, is there any further discussion on the committee report? Okay, all in favor of the committee report, please say aye.
Aye.
All opposed? Okay, the committee report is adopted. To the bill.
Thank you, Madam Chair. Members, in a nutshell, Community Choice Energy would allow communities served by an investor-owned utility to procure their electricity from alternative wholesale suppliers, much in the same way as municipal utilities do currently. The utility continues to own and operates its generation and transmission and distribution to deliver electricity and manage customer service and billing. Individual customers in a community that adopts Community Choice Energy would retain the ability to opt out and purchase their electricity from the utility as they do now. Typical opt-out rates are 5 to 10%. CCE must be authorized at the state level and allows communities to pursue at the local level. It would introduce community-level choice and market-based competition into the wholesale electricity sector. And just to remind everyone, this is a study. It opens a docket at the PUC, 23 well-considered questions. It does not change the status quo at all. Thank you.
Representative Basenecker.
Thank you, Madam Chair and members. I was asked to join this bill because I bring a different perspective, and that's the perspective of a representative from a district that includes a city, Fort Collins, that gets its electricity from a city-owned and operated municipal electric utility. Just a quick point of clarification, community choice energy, if enabled in the future, would only be available to communities served by an investor-owned utility or IOU, not to communities served by a municipal utility or electrical co-op. That being said, I bring two things to the table with this bill. First, I can speak to the power of choice that has allowed Fort Collins to pursue its ambitious renewable energy goals, 100% by 2030. And second, I believe that there are a number of ways that municipal utilities and co-ops might indirectly benefit due to competition in the wholesale market if CCE is enabled in Colorado in the future. I think it would bring more buyers and more competition to the wholesale electricity market, and a more vibrant wholesale electricity market with more independent power producers and power marketers would likely put downward pressure on the wholesale electricity prices and bring more innovative energy solutions to the market. And that benefits all of us. I'm pleased to represent this study bill. I fully support the two-step process that it represents, where CCE is first investigated at the PUC to learn if its demonstrated process seen elsewhere could be realized here in Colorado, and if so, how to best design CCE enabling legislation. I believe that it's shown sufficient promise elsewhere that a forward-thinking state like Colorado should certainly consider it. There's no harm in gaining more information. Thank you.
Representative Hooton, do I see an amendment? No, okay.
Madam Chair, I failed to move my amendment before I requested adoption of the committee report. So if the bill makes it to the Senate, we'll address the amendment over there.
Okay, thank you.
Or offer it on thirds. We'll see.
Okay, Representative Basenecker, Representative Hooton, any further comments on the bill? Okay, Representative Larson.
Thank you, Madam Chair. So members, first I want to start off actually by thanking the sponsors for bringing this bill and thank them for indeed raising an important issue here. This has a couple of contradictory issues for me. On the one hand, I am actually generally supportive of local communities wanting to make this step if they are unsatisfied with, for instance, a broader service area's timetable to get to their renewable goals. I do indeed think that we need to offer them an alternative. If the city of Boulder or the city of Fort Collins wants to move their renewable targets up faster than the rest of the XL service area or whatever service area they may be in, I think that that's an option that should be available to them and isn't under current law. And I applaud the taking the study approach. I think that's appropriate. My concern here is that this study is written in such a way that I think we have a predetermined outcome. And I think that there needs to be alternative considerations such as community partnerships and opt-in models. This is kind of an interesting predicament because we're for instance, in the XL service area, which the majority of my district falls in, is so broad and covers several different municipalities. So right now, my ratepayers in XL, in unincorporated Jefferson County, their rates are set by XL by what the Utility Commission granted them as a ratepayer, but they were assuming that they would have all of these customers in these other municipalities. My concern is, and hopefully the study will bear this out a little bit, is that if we go to an opt-out model and if we go to this model that's being proposed here, that you will have municipalities and communities making a choice to pursue an accelerated timetable for renewables, but you will have ratepayers that don't live in those municipalities that will be adversely affected by the decision of a city in which they don't live. So for instance, if Boulder decides to pull out of the Excel service area, utilizing this option, the people that live in my district and in unincorporated Jefferson County who did not have a vote on that issue, who did not make a decision there, will have an adverse impact potentially reflected in increased rates. And I don't necessarily think that that's a fair way to go about this. If communities want to weigh the economic pros and cons against, the climate change goals that they have, which I think is something that's totally appropriate, their decision should not impact people that did not have a vote in that decision. So while I applaud generally the idea of studying this, making an option available to communities that want to accelerate their timetable to address global warming, my ask would be that we take a broader look. We look at, community partnership. I know that there are strong feelings about this, and I know that there is indeed a history here with the previous speaker, but I think it's an option that's worth considering, particularly given that we're taking a study approach, which I do think is the appropriate one. So I would just ask that we amend some of the language in this bill that appears to be very leading and appears to be kind of pushing it toward a general conclusion about a predetermined outcome. Let's take a true broad look at all the options available to us, what this might mean for ratepayers, both inside of these districts that want to take that faster step, and the ones that will be affected who don't get a vote in that matter. So I rise in opposition to the bill as written, but I do applaud the idea behind it and the goal behind it. And hopefully this will get to a better place, but as written, I will be a no vote.
Thank you. Is there any further discussion? Representative Hooton.
Thank you, Madam Chair. I just want to point out a couple of things. This is a study bill. Some of the issues raised by Representative Larson will be addressed in the study bill. If you look at 1269, you'll see 21 questions in the bill that address your concerns around impacts on ratepayers, et cetera. The second, we are not creating a municipal utility. Boulder attempted for 10 years to do that, and they had suspended their agreement with Excel, and then this fall, the Boulder voters voted to re-engage with Excel. City Council continues to support CCE because all that does is give us an option, should it come to that, of procuring our own electricity that would still continue to be delivered by the incumbent utility.
Representative Pico.
Thank you, Madam Chair. It's an intriguing idea. I come from the background of having run a utility for 8 years, being on the board of directors. During that time, we took a, we're a municipal, so we're kind of focused on ourselves. But we looked at the broader market, and we hosted a delegation from both Boulder and Pueblo talking about precisely these issues of standing up their own municipal utility. And we talked them through the process. There is a process. It is already in present. This is a little bit different, CCE. And for the record, I also took a look at Fort Collins, and we were following that very closely, given that cooperative is presently, or the last time I checked, was 2/3 coal-powered. So how they transition is going to be something that we were watching with great interest, is how well they do that, given they've got double the coal in percentage terms that we do. But the issue I think that really concerns me is one that was already mentioned here, what it does to the other ratepayers in the neighboring communities. So the utility, regardless of how it's structured, is going to build the generation capacity or contract the capacity from some other place. They're going to build those assets to supply the demand. If the community opts out and goes away, that asset now is a stranded asset, which then that utility has to spread that cost over the remaining ratepayers elsewhere. And I think that's the shortfall in here. To that end, I offer an amendment. I move Amendment L004 and ask it to be displayed.
Thank you. L004 has been moved and is properly displayed. Representative Pico, can you please explain your amendment?
Thank you, Madam Chair. What this does is it adds one more constraint into the study, that the implementation of any option determined from the study cannot have a negative impact on other ratepayers outside of the municipality that is the focus of the study. That's what this does, is address that issue of the negative impact on other ratepayers outside the area. Representative Larson just spoke to that a moment ago about how the economic expense of having built and operating that asset to serve this community now has to be spread among the remaining. I think it's a good amendment. With this amendment, should it pass, I would be in support of the bill. I ask an aye for the an aye on the amendment.
Is there any further discussion on the amendment? Representative Hooton.
Thank you, Madam Chair and Representative Pico. I couldn't agree with you more. I think it's very important that the impacts on the ratepayers be considered, and there are several questions in the bill, and I will find those questions specifically and cite them for you. So I do believe that this amendment is a redundancy, and I would ask for a no vote.
Representative Holtorf, this is to the amendment? Thank you.
Thank you, Madam Chair, and yes, ma'am, this is to the amendment. To my esteemed colleagues, my neighbor here in the chamber, who has been on the Colorado Springs City Council and is very well versed in city governance and matters of energy and energy impact on the urban communities, brings forth a very strong and robust amendment that protects the consumer. Consumer protection is something that we are very, very concerned with as we move perhaps at an accelerated pace into this renewable energy or green energy environment that has been mandated in this state. My colleague, who is most concerned with consumer protection, brings forth this amendment in good faith. Now, in fact, some of the language in the bill may codify or speak to this. But here's what the amendment does, ladies and gentlemen. In the study, it removes any doubt. Now, where I'm from in the country, they say you need to shoot straight and talk straight and be very clear. Sometimes people don't understand country speak. But this amendment is a very straightforward amendment that makes it very clear, almost in the language that I understand, because it really says, the implementation of any option determined from the study, and the PUC is doing this study, and I would hope that that study would be purely objective and unbiased and would not have any political motivation whatsoever. But that could come into question.
Representative Hooton, can we please
As I continue to read the amendment, cannot have a negative impact.
Representative Holtorf, could we please not impugn anybody's motives on what may or may not be biased?
I haven't specifically impugned anyone. I've just said that we don't know, and I don't know. And I'd like to talk to the amendment here if I could. Cannot have a negative impact on other ratepayers outside of the municipality that is the focus of the study. Now, here is my real concern, and this is a good amendment. I even think if it's in the context of the bill, it should be considered a friendly amendment. But that's not my determination. I'm not the bill sponsor. But it looks like a friendly amendment. But what it does is it protects the consumer. Now, my big concern is if we travel down this road with these studies and these particular entities now and these communities start to spin off of what I think they call the electric grid, then who bears the burden of the cost as they get exempt? The power company has to recover this. It has to recover this cost to maintain in a positive cash flow position as they lose their customer base. Because if you're in business, small, medium, or large, what is the most important part of your business in your business model? Sales or service? It is your customer base. And it is having a robust customer base and maintaining your customers. But in this study, what potentially could happen as we move forward is, in fact, this study in the PUC is now going to allow for that customer base to be eroded, to be pulled away, to be off-ramped, if you will. So now what does that, and it's interesting that municipalities are exempted, because I think they shouldn't be. I don't think there should be any exemption. If it's good for the goose, it's good for the gander. Let everybody be exposed to the same risk of losing that customer base in the energy grid. But in this particular case, it says that you cannot do harm. You cannot do harm to the customer. You cannot create an imbalance that causes those individual customers that are not allowed to participate in this particular entity that you seek to study and create, that you cannot infringe upon on them. So somebody else is going to be there holding that weight to try to keep that particular electric company profitable and in business. So there is a concern. But to the amendment sponsor says, do no harm. Don't allow others in that to be damaged. And I'll let the amendment sponsor speak more to this, but I am in very much support of this amendment and what my colleague from Colorado Springs brings forth to this chamber.
Is there any further discussion on the amendment? Representative Hooton.
Thank you, Madam Chair. I am going to reconsider my recommendation to vote no on the bill. I've looked at the amendment more closely, and I think that's a legitimate concern, and we can add that as a question in the study bill. And just to make sure that everyone who's interested in this knows, Representative Pico's bill asks that the PUC consider the impacts on ratepayers outside of a community choice energy authority and assure that if there's any impacts that is noted, because this is just a study, and if it becomes favorable, then enabling legislation would ensue, and that would be a part of that bill too, is making sure that there are no negative impacts on ratepayers outside of community choice energy authority. That's my understanding of the amendment, and Representative Pico has confirmed that, so I do urge an aye vote on this amendment.
Excellent. So is there any further discussion on L004? Seeing none, all in favor of L004, please vote aye. Aye. Everybody opposed, please say nay. Okay, L004 is adopted. And I would like to take this opportunity in this sort of brief pause to welcome Representative Jovan Melton back to the chamber. Oh, and Representative Joe Salazar. My apologies. Sorry. My eyesight, old age. Okay, everybody. Representative Pico. To the bill.
Thank you, Madam Chair. With that amendment, I think this now limits this to a very effective study. I think it's going to take a look appropriately at the different options, and I reverse my previous opposition. I recommend an aye vote on this study bill.
Representative Hanks.
Thank you, Madam Chair. I listen to these proceedings with a certain amount of attentiveness, especially when it's a bill that I'm not privy to via committee. I'm grateful for the expertise of my colleague, Representative Pico. As we go through second reading, I do believe that there are elements called EEIs, essential elements of information we should be passing on to the people who are watching this, who are listening to this. I am struck when individuals come up here and offer appropriations reports that say something to the effect of, we were appropriated money, we told a joke, we won a prize. I don't think that qualifies as an essential element of information, and I do think the people deserve a little bit better than that. Accordingly, I ask that this bill be read at length.
Okay, that is a proper motion. The bill shall be read at length.
That's fine. Can I just make a comment?
Be it enacted by the General Assembly of the State of Colorado. 2 Section 1. In Colorado Revised Statutes, add 40-4-120 as 3 follows. 440-4-120. Study of community choice in wholesale electric. 5 Supply, duties of commission, report, legislative declaration. 6 Definition, repeal. 1. Legislative declaration. A. The General. 7 Assembly finds and determines that 14 communities in Colorado, known as the 9 Ready for 100 communities, have committed to obtaining 100% renewable energy by 2025 to 2035. In addition, 1135 communities, known as Colorado Communities for 12 Climate Action, have organized to advocate for stronger 13 climate change policies. These communities, which represent -2 HB 21-1269, more than 1 million Coloradans, are exploring ways to reach to their energy and climate goals within their desired time periods. 2. A key element of the Governor's policy initiative, 4 entitled Roadmap to 100% Renewable Energy by 2040 and Bold 5 Climate Action, prioritizes supporting local commitments to 100% renewable energy. 3. The ability of a community to achieve its Energy 8 goals is currently limited by the energy supply and the 9 decarbonization timeline of the electric utility that serves the 10 communities' geographic area. The ability to procure electricity 11 from alternative wholesale suppliers may enable communities 12 to achieve their energy goals faster and more cost effectively. 4. Community Choice Energy or CCE, also commonly 14 known as Community Choice Aggregation or CCA, is a local 15 energy model that a number of states have adopted and that has 16 proven to be effective in helping communities achieve their 17 renewable energy goals, cost containment goals, or both. 18 robust study of CCE would answer key questions and illuminate 19 the possible benefits and challenges of adapting the CCE model. 20 as an option for Colorado communities. 21. In the CCE model, communities that are served by an 22 investor-owned electric utility may choose their wholesale 23 electricity suppliers, while the electricity continues to be 24 delivered by the incumbent investor-owned electric utility. In 25 states that have enabled CCE to date, CCE is not permitted in 26 communities that are served by a cooperative electric 27 association or a municipally owned electric utility. 3 HB 21-1269. 6. In the CCE model, an investor-owned electric utility 2 continues to own and operate its transmission and distribution 3 system to serve both CCE customers and its own customers, and 4. The utility continues to provide metering and billing services, 5. Manage customer service, and implement demand-side 6 management programs. The utility continues to own and operate 7. Its power generation assets to serve its own customers. If a community chooses to adopt CCE, the utility would deliver the 9 electricity, with appropriate compensation, from 1 or more 10 alternative suppliers to CCE customers. 7. This section concerns the wholesale, opt-out 12 model of CCE, pursuant to which individual customers are 13 automatically enrolled in and retain the right to opt out of 14 their community CCE offerings and purchase their electricity 15 from the utility under its traditional bundled service. By 16 contrast, the retail model of CCE, in which individuals in 17 deregulated retail choice states can shop for their electricity. 18 from among many competing suppliers, does not promote the 19 stable revenue conditions needed for development of high 20 levels of renewable energy. The retail CCE model is explicitly 21 not the subject of this section. 22. A well-designed wholesale, opt-out CCE program 23 would introduce an element of wholesale competition and 24 community-level choice into the supply of electricity and could 25 provide communities that have ambitious renewable energy 26 goals, cost containment goals, or both, with a means to reach 27 those goals more quickly and cost-effectively. 4 HB 21-1269. 9. This section pertains only to the study of CCE, not to its implementation. While CCE in other states shows the 3 potential for communities to make local energy decisions, reach for their energy goals, reduce energy costs, and foster local 5 economic development and local employment, it is prudent to 6 first study the feasibility and the regulatory, legal, and 7 environmental implications of CCE in Colorado before 8 considering the implementation of CCE as an option for 9 communities in Colorado that are served by an investor-owned 10 electric utility. 11. X. The study of CCE as described in this section will 12. Answer key questions about the potential viability of CCE in 13 Colorado and will identify best practices and lessons learned 14 from the experiences of states that have already implemented 15 CCE. The study will provide the information needed to determine 16 whether CCE could provide net benefits to Colorado 17 communities. 18. 11. CCE, if enabled in Colorado in the future, could 19. Promote a more vibrant and competitive wholesale electricity 20 market and could enhance efforts to form or join a regional 21 transmission organization, which could increase the footprint 22 of energy trading in the West and thereby reduce costs through 23 market efficiency, lower required reserve capacities, increased 24 integration of cost-effective renewable energy, and decreased 25 curtailment of excess renewable energy. A regional 26 transmission organization could also potentially benefit 27 cooperative electric associations and municipal electric. -5 HB 21-1269. 1. Utilities. 2. B. Therefore, the General Assembly declares that it is in 3. The public interest to direct the Commission to evaluate the 4. Viability of the wholesale, opt-out model of CCE in Colorado 5. And to answer key questions about CCE in Colorado by 6. Conducting an investigatory docket that considers at least the 7 topics outlined in subsection 3 of this section. 8. 2. Definition. As used in this section, Community Choice 9 Energy or CCE means a mechanism that allows cities, 10 including a city and counties, or groups of cities and 11 counties to combine their purchasing power and choose 1 or 12 more alternative wholesale electricity suppliers on behalf of 13 the residents, businesses, and municipal facilities in the 14 jurisdiction while the incumbent investor-owned electric utility 15 maintains its existing generation and continues to own and 16 operate its transmission and distribution system and deliver the 17 electricity to both its own customers and CCE customers. 18. 3. Investigatory docket. A. On or before January 15, 2022, 19, and in accordance with this subsection, 3. The Commission shall 20 open an investigatory docket to accept testimony and 21 documentation from stakeholders, independent energy, and 22 utility experts, regulators from states in which CCE has been 23 implemented or is under consideration, representatives of 24 operational CCE authorities, and other interested parties. The 25 goal of the proceeding is to consider the regulatory 26 implications and legal impacts of possible future CCE enabling 27 legislation and provide recommendations to the General. -6 HB 21-1269. 1. Assembly. Conclusions should include best practices and lessons 2 learned from states that have enabled CCE at the wholesale 3 level. The Commission shall employ procedures that promote a 4 productive, effective, and evidence-based process, including 1 5 or more commissioners' informational meetings with 6 presentations by subject matter experts. 7. B. The Commission shall solicit input from a broad and 8 inclusive range of stakeholders and presenters to ensure that 9. The process is not dominated by any one group or viewpoint. 10. Stakeholders and presenters may include 11. I. Local governments with declared goals regarding 12. Carbon emissions or energy supply choices. 13. 2. Business groups. 14. 3. Environmental advocates. 15. 4. Consumer advocates. 16. V. Electric utilities, including investor-owned electric 17 utilities, municipally owned electric utilities, and cooperative 18 electric associations. 19. 6. Independent power producers. 27. Power marketers. 21. 8. Renewable energy developers. 22. 9. Consultants or other experts in energy project. 23. Financing. 24. X. Consultants or other experts in energy efficiency. And 25. Distributed energy resources. 26. 11. Representatives of operational CCE authorities that 27 use the wholesale CCE model. N-7 HB 21-1269. 1. 12. Members of the general public. 2. C. The topics and questions to be explored in the docket may 3rd include 4. I. Whether the Commission would require additional 5 statutory authority to conduct a rulemaking proceeding. 6. Concerning the creation of CCE authorities in Colorado, except 7. That the Commission's determination that additional statutory 8 authority is not required does not preclude the General 9 Assembly from increasing or amending the Commission's 10 statutory authority. 11. 2. The appropriate scope of regulatory oversight of CCE 12 operations, on a scale ranging from comprehensive, as with 13 investor-owned electric utilities, to minimal, as with 14 municipally owned electric utilities. 15. 3. Which aspects, if any, of current or anticipated 16 investor-owned electric utility regulation by the Commission. 17. Should apply to CCE authorities as well, and to what extent. 18. Including regulation in the areas of 19. A. Resource adequacy planning. 20. B. Assurance of reliability and how this is paid for. 21. C. Compliance with renewable energy standards and 22. Emissions reduction targets. 23. D. Supplemental demand-side management programs. 24. Offered by CCE authorities. 25E. Time of use rates or other rate requirements if 26 mandated for investor-owned electric utilities, and 27F. Standards for requests for proposals. -8 HB 21-1269. 1. 4. The appropriate principles and considerations for 2. Calculating the amount and duration of reasonable transition 3 fees, also known as exit fees, that communities forming a CCE 4 authority would pay to the incumbent investor-owned electric 5 utility to offset their fair share of the costs of utility assets 6. In contracts that were procured on their behalf, and 7. Previously approved, in amounts sufficient to provide cost 8. Recovery for stranded investor-owned electric utility assets 9. In contracts and direct transition costs while protecting 10 non-CCE customers but without unduly burdening CCE 11 customers. The principles and considerations may include 12a. The age or the date of initial service of Generation 13 assets and existing contracts. 14b. The potential for exit fees to vary over time or by 15 location. 16c. The establishment of a specific expiration period for 17 exit fees. 18d. Measures to mitigate exit fees through potential. 19. Contract transfer or resale to CCE authorities or other buyers. 20. Inappropriate forecasting of departing load to avoid 21. Overprocurement, and 22e. Pitfalls encountered in other states related to exit 23 fees and how those pitfalls could be avoided or mitigated by 24. Upfront consideration. 25v. The appropriate conditions, limitations, and 26. Procedures under which customers may opt out of CCE, and 27. Receive bundled service from the incumbent investor-owned. -9 HB 21-1269. 1. Electric utility. 2. 6. Whether any additional consumer protections would 3 be required and the means of providing those protections. 4. 7. Potential challenges for CCE startup or continuing 5 operations, including the availability of financing and credit. 6. Rating considerations and strategies to overcome those 7 challenges. 8. What regulatory and legal issues have arisen in 9 other states that have adopted the wholesale, opt-out model of 10 CCE and possible solutions for those issues. 11. 9. Whether an investor-owned electric utility that 12 remains the sole provider of distribution, transmission, and 13 other services traditionally provided by the utility, such as 14 metering and billing, should also be the provider of last resort. 15. For supplying electricity to customers who opt out of CCE. 16. X. The appropriate process for approval of CCE on behalf 17 of customers within a jurisdiction, whether by ordinance, by 18 vote of the people, or otherwise. 19. 11. Whether CCE authorities should be allowed to offer 20. Demand-side management programs that either expand upon or 21. Replace such programs offered by the incumbent investor-owned. 22. Electric utility. 23. 12. Regulatory and policy considerations related to 24. Forming CCE authorities in a state that does not currently. 25. Belong to a regional transmission organization or participate. 26. In a wholesale electricity market, and possible solutions. 27. Including considerations in the areas of -10 HB 21-1269. 1a. Whether legislation should be adopted to guarantee 2. Open access and fair prices for transmission services. 3b. Recommendations for legislative or administrative form measures, or both, concerning wholesale market access. And 5. Development in Colorado. And 6c. Whether other legislative and regulatory 7. Modifications are necessary to successfully implement CCE. And 8. Colorado. 9. 13. What, if any, minimum requirements and standards 10 should apply to independent power producers and power 11 marketers who wish to supply energy to a CCE authority. 12. 14. What, if any, data sharing requirements should be 13 imposed on investor-owned electric utilities to help ensure that 14. A CCE authority or a jurisdiction investigating whether to form 15 or join a CCE authority can reasonably evaluate its financial 16 and technical viability and implement its CCE program. 17. 15. How CCE might facilitate or impede. 18. A. Increased integration of distributed energy. 19. Resources, such as rooftop solar, community solar, and battery. 20. Energy storage into distribution systems, and 21. B. Increased investment in beneficial electrification. 22. Including electrification of transport. 23. 16. The appropriate considerations for ensuring that 24. The implementation of CCE does not include customers in the 25 certificated territories of municipally owned electric utilities. 26. Or cooperative electric associations. 27. 17. The impact of allowing CCE in Colorado on the -11 HB 21-1269. 1. Ability of Colorado to reach its clean energy and greenhouse 2 gas reduction goals, and what legislative and regulatory 3 requirements for CCE would be needed to facilitate reaching 4 those goals. 5. 18. The impact, both positive and negative, of CCE in 6 communities that have formed or joined a CCE authority in 7 states that have enabled the wholesale, opt-out model of CCE. 8. 19. The impact of CCE on low-income households. 9. Including the availability of low-income programs offered. 10. Through the investor-owned electric utility to CCE customers. 11. And the ability of CCE authorities to establish additional 12 programs to assist low-income households. 13. XX. The risks a CCE authority might face that merit 14 consideration, such as resource price risks, contract risks, or 15. Load defection, and the significance of those risks. And 16. XXI. The impact of CCE on jobs in the electricity sector. 17. D. The Commission shall summarize its findings. 18. Conclusions and recommendations from the investigatory 19 docket in a final report submitted to the Transportation and 20 Energy Committee of the Senate and the Energy and Environment 21 Committee of the House of Representatives, or their successor 22 committees, and posted on the Commission's public website. The 23 Commission shall submit the report on or before December 15, 24, 2022. Recommendations may be split into majority views and 25 dissenting views if necessary. 26. 4. Repeal. This section is repealed, effective September 1st, 27, 2024. 12 HB 21-1269. 1. Section 2. Safety Clause. The General Assembly hereby finds. 2. Determines and declares that this act is necessary for the immediate 3. Preservation of the public peace, health, or safety. 13 HB 21-1269.
Is there any further discussion on Representative Hanks?
Thank you, Madam Chair, and thank you for the indulgence on the reading of that bill. What I want to move to now is the pink sheet that we all get, the fiscal note, and I want to advise those paying attention that for budget year, fiscal year 21-22, this will require an expenditure of $61,733 and 0.5 FTE, full-time equivalent. For the out year, 22 and 23, the expenditures are $54,796 and also another half FTE. I'd like to advise all interested parties that this bill, House Bill 21-1269, did pass through the House Energy and Environment Committee on a party line vote. It won 7-5. I urge a no vote.
Is there any further discussion on Representative Van Bever?
Thank you, Madam Chair. I'm on the Energy and Environment Committee, and I had a few thoughts as I listened to this bill, and I was a respectful no at that time. When I looked at the bill, one of the first things that jumped out at me is page 3, lines 7 through 12, where it says the ability of a community to achieve its energy goals is currently limited by the energy supply and the decarbonization timeline of the electric utility that serves that community's geographic area.
Excuse me, Representative Van Bever. Hey, everybody, can you please take your conversations off the floor? It's getting a little loud in here and I'm having trouble hearing. Thank you.
Thank you, Madam Chair. The ability to procure electricity from alternative wholesale suppliers may enable communities to achieve their energy goals faster and more cost effectively. And of course, it hit me at that time, being from a portion of the state where we have had a cost-effective, safe, and plentiful energy that was derailed in the zeal to ensure that we have these energy goals met. And what I would have liked to have seen as a constituent in that area in northern Colorado is that there was an invitation and cooperative effort to provide those energy sources. That enables ingenuity, it enables creativity and entrepreneurship in the business world that does allow us to meet our energy goals. And I don't know that that was always done with the fidelity that I would have liked to have seen. The second thing that did come up was reliability and resilience. That's a topic of great importance to me based on transformer issues that occurred in my portion of the state, just 2 miles from my home, where a transformer had to be removed, both in Forbes magazine and in the Wall Street Journal. It was noted that an energy transformer just 2 miles from my home had to be removed due to concerns about energy issues, energy pieces, parts, and devices placed on that transformer that could have been used to shut it down. That, my friends, is a national security issue, and a security issue of epic proportions locally for me as an energy consumer. And while I can appreciate those topics as well being pursued with this bill, I think the last thing that I would like to bring up is I've heard the power of choice mentioned over and over and over again. And as I think about what the context of the word choice means, it means to me, or the clarification of that word means that all options are available as possible to choose from. That's choice. But when a local entity is having their energy options reduced, restricted, you cannot possibly say that that 2 + 2 = 4, because it does not. It equals 5. And that doesn't make sense. To say we have choice when our restrictions and the options decrease, then we do not have choice. So what I'd like to do with this bill is offer an amendment. It's a friendly amendment, and I've already spoken to the bill sponsors. And I'd like to move L005, please, and have it properly displayed.
Thank you. L005 has been moved and is properly displayed. Would you like to tell us about your amendment, Representative Van Beber?
Yes, thank you, Madam Chair. So what this amendment does is when it comes to the questions that we'll be posing to the PUC, to the stakeholders, to the consumers, and to all the individuals who will be a part of this discussion, when we look at the bill, it says these things may be discussed. And we have taken that word may out and changed it to shall, because those things must be discussed. And the only way that they will be discussed is if we say they shall be discussed. So that is the amendment, and I ask for an aye vote on that amendment.
Is there any further discussion on L005? Okay, Representative Pico.
Thank you, Madam Chair. I think this adds a lot of clarifying to the intent of the bill. I note that it's passed on a party line vote in the House Energy Committee, but as I say, with the amendments being offered and accepted, I'll flip to a yes.
Representative Sandridge, would you wish to speak to the amendment? Please.
Thank you, Madam Chair. I do stand in support of this amendment and appreciate the main sponsor's consideration on this. I think this does resolve some of the concerns associated with this bill, and we'll definitely, I think, add a few yes votes to the bill. But I appreciate the consideration of this. Thank you.
Representative Hooton.
Thank you, Madam Chair. I do consider this a friendly amendment, and I support it. I urge an aye vote. Thank you.
Okay, thank you. Further discussion, Representative Pelton.
Thank you, Madam Chair. I rise in support of this amendment. This still gives choice to the consumer, and I'm all about choice, so I urge an aye vote.
Representative Will.
Thank you, Madam Chair. It's an honor to serve with you.
It's an honor to serve with you, Representative Will.
I stand in strong support of this amendment. I think, I understand this is a study bill and it's not enabling legislation, so I totally stand in support of this amendment. I think it's a good amendment.
Thank you. Any further discussion on L005? Representative Woog.
Thank you, Madam Chair. I also support this amendment. Anytime there's uncertainty in legislation that will create future problems, this just brings a little more certainty, so I urge an aye vote on this amendment.
Thank you. Representative Holtorf.
Thank you, Madam Chair. I also, in turn, am very encouraged by the change in language, and I encourage a yes vote on this amendment because it does redirect and make that conversation take place within the PUC work study group that is so important with respect to choice.
Okay, any further discussion on L005? Seeing none, the question Okay, a division has been requested on L005. Representative Hooton?
Members, I just want to remind everyone that the bill sponsors are a yes on L005.
Thank you, Representative Hooton. I think Okay, thank you. A question is, a division has been called. Sorry, I'm trying to. Okay, the question is the adoption of L005 to HB 21-1269. All those in the chamber not entitled to vote, please be seated. All those in favor of L005, please stand and remain standing or raise your hand and keep it raised until the count is taken. The chair is not in doubt of the results, so the L005 is adopted. Thank you, everyone. Is there further discussion on HB 21-1269? Seeing none, the question before us is the adoption of HB 21-1269. All in favor of the bill, please say aye. Aye. All opposed, please say no. Okay, HB 21-1269 is adopted. The next bill up is HB 21-12. Oh, Madam Majority Leader.
I have a quick recess.
Quick recess, please.
But you don't want to go at all.
Majority Leader.
Thank you, Madam Chair. I move to lay over House Bill 1209, one bill.
Oh, the House will come back to order. Yes, Madam Majority Leader, you may.
Thank you, Madam Chair. I move to lay over House Bill 1209, one bill.
Seeing no objection, we will move HB 21-1209 over one bill. The next bill up is HB 21-1276. Mr. Gregorio, will you please read the title?
House Bill 1276 by Representatives Kennedy and Harrod, also Senators Pedersen and Priola, concerning the prevention of substance use disorders.
Thank you. Representative Kennedy.
Thank you, Madam Chair. I move House Bill 1276 and the committee reports from Health and Insurance and Appropriations.
To the Appropriations Report.
Thank you, Madam Chair. In the Appropriations Report, we did appropriate funds from the Marijuana Tax Cash Fund for community prevention and treatment programs, as well as some FTE that were needed. Actually, I'm sorry, I'm incorrect about the FTE. It was primarily for the community prevention programs. I ask for an aye vote.
All in favor of, is there any further discussion on the Appropriations Report? Seeing none, all in favor of the Appropriations Report, please say aye.
Aye.
All opposed? No? The Appropriations Committee report is adopted. To the Health and Insurance Committee report.
Thank you, Madam Chair and members. Just to give you a heads up about what's about to happen, I'm about to offer 8 amendments. They are all the results of stakeholding I've been doing over the course of this process. I move Amendment L11 and ask that it be displayed.
Thank you. L011 has been moved and properly displayed.
Thank you, Madam Chair. Members, this amendment came out of conversations with the physical therapists to make sure that we correctly spoke about how the physical therapy visits were to work in this bill. I ask for an aye vote.
Thank you. Is there any further discussion on L011? Seeing none, all in favor, please say aye.
Aye.
All opposed? No? Okay, the ayes have it. L011 is adopted. Representative Kennedy.
Thank you, Madam Chair. I move Amendment L12 and ask that it be displayed.
Okay, L12 has been properly moved and it's been being properly displayed as well. Representative Kennedy, would you please like to explain the amendment?
Thank you, Madam Chair. Members, this amendment was requested by the Division of Insurance to make sure that if the federal government deemed that this was going to force the general fund to have an impact, that this part of the bill would not go into effect. So this is, in essence, an escape clause in the event that this drives a cost to the state. I ask for an aye vote.
Any further discussion on L012? Seeing none, the question before us is the passage of L012 to 1276. All in favor, please say aye.
Aye.
All opposed? Okay, the ayes have it. L012 is adopted. Representative Kennedy.
Thank you, Madam Chair. I move Amendment L15 and ask that it be displayed.
L015 has been moved and is properly displayed. Representative Kennedy.
Thank you, Madam Chair. Members, this amendment came out of conversations between Mental Health Colorado and the Colorado Cross Disability Coalition. I also have to make a quick mention of some sad news related to one of the stakeholders I worked with on this bill. I don't know if any of you knew Valerie Schlecht, who was often a witness in our bills and testified on them. She was also the lead stakeholder for the Cross Disability Coalition, helping work out this amendment. She, after being unresponsive for a few days, was unfortunately found dead in her home yesterday. I don't have a lot of details about what happened. I think we'll keep you all posted on that. But I apologize for doing this in the middle of a bill, Madam Chair, but I would ask for a brief moment of silence.
A moment of silence is granted.
Thank you. So this amendment came out of conversations with Valerie and others. There was a concern that as we try to make sure that there's not overprescription of opioids and benzodiazepines, that we also recognize that there are many patients who very much need these medications to survive, particularly in the chronic pain and chronic condition community. So this amendment provided some extra protection for that community, and I ask for an aye vote.
The question before us is I'm sorry, is there any further discussion on L012? I'm sorry, 15. Representative Hanks.
Thank you, Madam Chair. I'm looking at the rule book, looking at 7 Charlie 9. We've got 8 amendments. I strongly recommend and I move that we refer this bill back to the Health and Insurance Committee. Let's get this sorted out in committee, get it cleaned up. Let's get it read at length as built.
Was that a request to read the bill at length? And is that, we're going to take a brief recess because I'm not sure if that's an appropriate motion in the middle of, I heard 2 motions. And we're taking a brief recess. The committee will come back to order. So we have been figuring out the procedural stuff here. What we're going to do is we are going to finish the amendment before moving on to any motion. So we are in the middle of hearing L015. Is there any? Representative Hanks.
Thank you, Madam Chair. I withdraw the motion to send this back to committee until we are done with this amendment, and then I'll readdress. Thank you.
Thank you, Representative Hanks. Okay, is there any further discussion on L015? Seeing none, the question before us is the adoption of L015 to the 1276 Health and Insurance Report. All in favor, please say aye.
Aye.
All opposed, no. The L015 is adopted. Representative Hanks.
Thank you, Madam Chair. So I believe we are at a point where I may make a motion that we send this back to Health and Insurance and look at these 8 amendments and reconstruct this thing and make it easy for those who are not on the committee to clearly understand what we're doing here, rather than what in my opinion is a bit of a hodgepodge. I make a motion that we send it back to Health and Insurance. Thank you.
Okay, the motion is to refer HB 1276 back to Health and Insurance. Representative Kennedy.
Thank you, Madam Chair. I ask for a no vote.
Okay, I understand this is a debatable motion. Representative Rich.
Thank you, Madam Chair. As we're getting closer and closer to the end of this session and these amendments are coming in at warp speed, I think it's only fair that this bill be sent back to Health and Insurance.
Representative Lontine.
Thank you, Madam Chair. As the chair of the Committee of Reference that is being asked to have this referred back to, I have a couple things I'd like to say. One is that Representative Kennedy has been working on this bill for quite some time, and even as we were hearing the bill in the committee, he did note that he was continuing to work with stakeholders on several of the outstanding issues, and that he expected that he would have further amendments upon second reading, and yet we still voted the bill out of committee. We often entertain amendments of substance in second reading, and this is just a continuation of that process on this specific bill. And so with that, I would ask for a no vote on this motion. Thank you.
Representative Soper.
Thank you, Madam Chair. I also rise in support of the motion to send this back to the Health and Insurance Committee. I sit on the Health and Insurance Committee, and I heard this bill. Although hearing that there's 8 amendments that are going to pretty much drastically change this bill, turn this into a completely different bill than what we heard in Health and Insurance Committee, certainly tells me that really this ought to go back to the Committee of Reference so that we as the committee members can go ahead and have that testimony, have that dialogue, dig in deep, be able to analyze the amendments, and then bring that back to the floor for the members to look at. That's the process we have. It's a time-honored tradition. It's the work of the committees. I mean, that's how we parse things out here. We don't necessarily do everything on the floor. The other thing is, knowing that there's 8 amendments, it really should have been combined together as one strike-below amendment, handed out ahead of time using the 24-hour rule so that all of us would have had the opportunity to have read and analyzed and studied what's actually going on to the bill here, rather than just parsing it out into 8 different amendments, knowing that we're going to get about 10 seconds to read each one of the amendments on the big screen, and then we'll have to make a decision. That's no way to govern. That's no way to make a decision. It makes it very hard to know what we're actually voting on. So I would at least like time to read, contemplate, and analyze, and the most appropriate way to do that is to send it back to the Committee of Reference. So I ask for a yes vote. Thank you.
Representative Van Beber.
Thank you, Madam Chair. As somebody who is on this Health and Insurance Committee, and as somebody who comes from a district who is deeply impacted by the opioid crisis. With all due respect to the bill sponsors and the statement that you've spent a great deal of time, and somebody spoke to the sponsor, that you've spent a great deal of time working on this bill, working with stakeholders, I would respectfully also, I'm in support of this amendment in that you're right, thoughtful policy does take time. And we as legislators are committed, if not, should feel the burden of ensuring that we take all of the time necessary for such a topic to be looked at in depth so that we can take the perspective of information as we see it flow from beginning to end. This is a disrupted, disconnected process, if you will, at this point. And so I'm in favor of having this go back to the Health and Insurance Committee for us to begin anew. Thank you.
Thank you. Representative Williams.
Thank you, Madam Chair. Members, I rise in support of this motion to refer it back to the committee. As a member of Health and Insurance, I think there's a lot of merit to what Representative Hanks is trying to attempt to do here. Since there is a number of amendments that are being proposed right here on second reading, it would presuppose that perhaps more work needs to be done, and the proper venue should probably be in the Health and Insurance Committee. And I think that would help us be able to move on to perhaps other bills on the calendar, since this bill is not quite ready for debate. But with that, I do agree with Representative Hanks and ask that you vote yes.
Representative Will.
Thank you, Madam Chair, and I stand in support of Representative Hanks' motion to send this back. I have the utmost respect for Representative Kennedy. I know he does good legislation and a good legislator. But when you're running 8 amendments on second reading, I'm not sure that's a good way to make good policy. So I strongly support sending it back to committee and get this hashed out. Thank you.
Representative Sandridge.
Thank you, Madam Chair. And I also stand in support of this motion. I think some of the amendments are significant, probably needed, and may make this bill better. But we need time to digest some of these amendments. I think this bill, a lot of us can get behind. We want to make sure it's crafted properly and make sure that we can take time and read these amendments in a manner where we can consider our constituents and their needs. We'll know, I know it may feel this way, but we're in no rush. And it'd be nice to send this information back to the Health and Insurance Committee, let them process it before we get it. Remember that whenever you rush legislation, unintended consequences come up. And when we're dealing with opioid abuse, we don't need any unintended consequences. We need a slow, methodical way of constructing this bill. I think this motion does that. So this bill's a big deal. We're dealing with people's lives here. I think we need to be slow and methodical, allow people to process these amendments, possibly do a strike below, and come up with a great product that we've been able to sleep on some. So let's not rush so much that we throw this bill together with these 8 amendments. Let's take our time. This is a real big deal, and send it back to the committee. Let them process it, and then come back here with the final product. And I think it'd be something that a lot of us could get behind. So I ask for an aye vote on this motion. Thank you.
Representative Pelton.
Thank you, Madam Chair. I happened to sub into that committee that day that we heard this bill. I was a no vote in committee. With this many amendments, I think it only appropriate goes back to the committee reference. That way they can flush it out in that committee and bring us a good product back. This It's a pretty tough subject we're dealing here. Everybody wants to do the right thing. So let's send this back to committee and get it right, then bring it back.
Representative Holtorf.
I'm on your side on this one.
You are?
Yeah, watch.
Thank you.
Thank you, Madam Chair. And I know that the drug addiction, drug abuse, and drug misuse epidemic in this nation and in this state is a terrible crisis. When we can't even walk across the street to our offices and we look at the epidemic right in front of us, it shows how critical this is. Most of you don't know this, but as I walked with my aide this morning to the building, I said, "What is that?" This glass device, little long, obtrusive little thing with a little round thing on the end. I said, "What is that?" In a pile of clothes and someone's personal effects. And my aide said, "Well, that is a crack pipe or meth pipe." I said, "You got to be kidding me." So you know what I did, madam? I stepped on it and crushed it, because that is how corrosive and divisive this problem is right here surrounding this Capitol. But I will tell you, the bill sponsor who has brought this bill forward is sincere in listening to the needs of the stakeholders that have spoken. So he brings these amendments forth on second reading in the committee of the whole. Now, I will also agree that when we have a plethora, a large amount, for my country folk, of bills and amendments that come forth on second reading, that is a red flag. But the bill sponsor, in good faith, I think, is trying to correct and clean up a mess or some messes and some things that might be contextually need to be modified or enhanced in this bill. But I do think that we have to be very deliberate as we, in this state's capital, address the multi-layered problem that is a part of this bill. Preventions of substance use disorders. And now my concern as we run these amendments is the following. We are putting a great burden on the medical and practitioners, the insurance providers. An enormous amount of legislation is being promulgated and put forth in this space. But what are we doing truly on the streets, within our youth, within this community, the drug abuse, drug misuse, or drug addicted community, to get them off the drugs, to get them, these folks, to walk away from that addiction, to walk away and say, "I don't want to live this way." I don't know if all these amendments are going to take this particular bill, House Bill 21-1276, into that arena. And I believe it may be out of context, in fact, to have amendments that would work towards this end. Our society, our nation, our society, our communities, both rural and urban, need to walk away from this addiction, from the corrosiveness and divisiveness that is substance use disorder, which is the new nomenclature, which in my community was previously referred to as drug addiction. It's a real problem. But I will tell you that the bill sponsor, I believe in good faith, is trying to fix some problems that did not get fixed in the committee of reference. But truly, as a young legislator in this chamber, am learning is that good stakeholder work is done early, it's done often, and it's done in committee. So, with all the best of intentions to the bill sponsor, I do support you in what you're doing at this time. I have mixed feelings on which way to vote on the amendment. But I think, or not the amendment, but rather the motion, the motion. But I do think the best work is done, truly, I think, beginning first prior to the bill coming to the committee of reference, which I've watching the majority leader do a great job of on some other legislation that I'm co-sponsoring with her. I mean, I'm amazed, truly amazed at the work that's getting done before we get to committee of reference. And I'm learning from that. And also, when we get to the committee of reference, I think we have to be very open to those amendments that come forth and not just reject them in whole or reject them because, and I've seen good amendments in committee. I've seen a gentleman right here before me bring one of the best amendments I've seen as a legislator that did not make it on the bill because of very many factors and reasons, but the perception that that's not the place to be offering amendments, which I do believe it is. But also, in the committee of the whole, ladies and gentlemen, we've got to have this discussion and dialogue, and this is also a good place to be fixing things before we go to thirds. So here we are today discussing this in this particular motion. But I will tell you, let us not push back and reject any opportunity at any point, be it in the committee of reference or in another committee, finance or appropriations, or in the committee of the whole, to accept and correct faults or flaws that were overlooked anywhere in the step of the process. And Madam Chair, I'd like to thank you for your patience and your attention and not giving me the hickory up there.
Is there any further discussion? Representative Ransom.
Thank you, Madam Chair. When I have constituents and interested parties contact me on any bill, I hesitate to commit really strongly and in advance because so many times we see amendments come through that change the intent of the bill, that change even sometimes very strongly, they'll change the way the bill works, they'll change the money, they'll change the fiscal note, and sometimes the bills are, the bill itself might be something I like or don't like, but then amendments will literally change how the bill and change my vote on the bill. So with this one, the introduced version was looked at, it was examined by constituents, by residents of Colorado, by lobbyists, by all the different groups that have interest in what we are doing here in the chamber. And then we have committee reports from the different committees where the bill is heard. And the one that came out of Health and Insurance that we are talking about and has not been approved yet is 3.5 pages. And that is actually good work. That is exactly what the committees of reference are supposed to do. That is what we are supposed to do, is look at the introduced bill, continue stakeholder work, figure out how we can improve the bill. And clearly, I have seen bills come through this chamber that either I supported but I didn't support an amendment, or bills that I opposed but then I supported amendments that literally brought the bill closer to where I could be in a position of support. And now on second reading, I know that stakeholder work continues. With that, I commend the sponsors for continuing the stakeholder work and bringing in these additional amendments. But then when we have 3 amendments that have been approved on top of a 3.5-page committee report from the committee of reference, we're putting layers upon top of layers as we're trying to work with this bill, satisfy stakeholders, satisfy the people involved, and make sure that the bill does what it was originally intended to do and what it is supposed to be doing. And so when we have these different layers upon top of layers, it becomes very difficult because amendments are up there during the process on the screen for just a few minutes. We can look at them on our iPads. We can try to get copies of them, but then it's very hard to take the original introduced copy of the bill, fold in the amendment, figure out exactly what it does, and many times I have introduced copies of the bill where I've taken amendments L012 or whatever, and then I'll mark up the introduced version so I can see exactly what that amendment was doing. Because clearly sometimes the committee reports are just saying, for example, on this one, page 6, strike lines 4 and 5 and substitute, and then it has a partial sentence. And it just makes it very difficult as a non-lawyer to figure out exactly what any given amendment does. And again, then when we're amending amendments or amending the committee reports, which is in effect amendments, it just gets very, very complicated. So with that, when I heard the motion, when we have this many amendments on top of lengthy committee reports, it really makes sense to let it be heard again by the committee of reference and let people that testified the first time, they may change their position based on these amendments. And I think it would be nice for the committee of reference to actually know that, to actually be told by constituents that their position on the bill may have changed or may not have changed. But in any event, we are continuing action here without giving an official place for constituents to come weigh in on. So for this to go back to the committee of reference, I understand that chairs can give time limits for testimony. It can be done much quicker than the first time the bill was heard, but it would just allow everybody to see the version of the bill they're voting on with all those layers of amendments on top of amendments, have time to get it all put together, marked up, whether they get an engrossed version or not. It would be an exact, they could mark up the bill and know exactly what they're voting on. So with that, I would like to see the committee members have another chance to take a look at this bill. And I thank the member that made the motion to refer this back to committee. I urge an aye vote, and I hope that you will let this bill go back to committee. It is a complicated bill on a complicated issue, and this will allow the committee members to actually see everything in one place, put it all in one pile, put it all in one document, and then make their proper vote on it. So I urge an aye vote, and thank you very much.
Thank you. Is there any further discussion on the motion to refer this bill back to Health and Insurance? Seeing none, the motion before us is to refer the HB 1276 to the Health and Insurance Committee. All in favor, please say aye. Aye. All opposed, please say no. No. The noes have it. This motion is adopted. Madam Majority Leader. Oh, I mean, sorry. The motion failed. My apologies. My apologies. The motion failed. Sorry. Sorry about that. Madam Majority Leader.
Thank you, Madam Chair. I move to lay over this bill as amended to the end of the calendar.
HB 1276 will be moved over till the end of the calendar. Madam Majority Leader.
Thank you, Madam Chair. I move the committee rise and report.
The motion has been made that the committee rise and report. Seeing no objection, the committee will rise and report.
No amendment. The House will come back to order. Mr. Gregorio, the report of the Committee of the Whole.
Mr. Speaker, your committee of the whole begs to leave to report as under consideration the following attached bills, being the second reading thereof, and makes the following recommendations thereon. House Bill 1269 is amended, passed on second reading, and ordered, engrossed, and placed on the calendar for third reading and final passage. House Bill 1276 is amended, laid over.
Representative Kipp. You have heard the motion. There are no amendments at the desk. The question before us is the adoption of the report of the Committee of the Whole. Mr. Gregorio, please open the machine, and members, please proceed to vote. Representative Neville, how do you vote?
No.
Representative Neville votes no. Representative Van Winkle, how do you vote?
No.
Representative Van Winkle votes no. Representative Jackson, how do you vote?
Yes.
Representative Jackson votes yes. Representative Harrod, how do you vote?
Yes.
Representative Harrod votes yes. Representative McLaughlin, how do you vote?
Yes.
Representative McLaughlin votes yes. Representative Luck is excused. And I think that just comes down to you, Representative. Oh, great. Please close the machine. With 39 aye votes, 22 no votes, and 4 excused, the report of the Committee of the Whole is adopted. Majority Leader Escar.
Thank you, Mr. Speaker. I move to lay over the balance of the calendar until tomorrow, Friday, May 21st.
Seeing no objection, the balance of the calendar will be laid over till Friday, May 21st. That brings us to announcements and introductions. While people are... Representative Soper.
Thank you, Mr. Speaker. And I wondered if Representative Duran could also join me for a second. So today is a very special day, and the two of us have definitely been focused on our dogs, our furry friends throughout the session. Today is National Rescue Dog Day, and I certainly want to just make that announcement because if you have the opportunity to rescue a dog, today is that day to do it.
Representative Duran.
Thank you, Mr. Speaker. Yes, if you have an opportunity, it's extremely important to adopt, rescue, give one of these furry friends of ours a forever home. And thank you.
Thank you.
Representative Byrd.
Members, I just wanted to give you a quick reminder that we have House Finance meeting upon adjournment. I'm going to give you all until 11:45 to make it to the Old State Library to begin our hearings.
Representative A. Valdez.
Thank you, Mr. Speaker. Members of Energy and Environment, we will be meeting at 1:30 in LSBA across the street to hear 4 bills, 1303, 1318, Senate Bill 108, and Senate Bill 230. See you there.
See no further announcements. Representative McCormick.
Thank you, Mr. Speaker. Ag, Livestock, and Water will also meet at 11:45 downstairs. Thank you.
Thank you, Representative McCormick. See no further announcements or introductions. Majority Leader Escar.
Thank you, Mr. Speaker. Members, if I can have your attention for just a second before we recess. We will be working through the day and possibly through the night tomorrow, so I just want to give everybody a heads up. Prepare to be here all of the day, and what we may possibly be moving into Saturday, and depending on how Saturday goes, could be Sunday. We just have a lot of work we have to clear, and we're going to clear it off the calendar and keep moving for the people of Colorado, get the work done. Thank you. With that, I move the House stand in recess until later today.
All right. Usually we don't clap in the chamber. See no objection. The House will stand in recess till later today.